criticism, rightly or wrongly. They have been drawn into the public arena, where they do not belong. And that is sad for the institution, because the monarchy as a whole, as conference of rulers and individually, they have a very significant role to play in our constitutional structure. That's been damaged to some extent. Then the second institution is the police. Now, of course, the police, we know what they did. They blockaded the assembly on the 5th of March. They locked out the assemblymen, which resulted in the tree sitting. People forget about why you had to have the tree sitting. And the reason is the police did not allow Sivakumar and the other assemblymen to enter the assembly. So, and leaving aside the doctrine of necessity and the fact that venue doesn't matter, I am commenting on the role of the police, and that is terrible. That they shouldn't be doing that. And then, of course, the second episode is the physical manhandling and removal of Speaker Sivakumar on the 7th of May. And again, there are any number of stories, and of course it was captured by cameras on the net, how he was forcibly removed, and the position taken by the Pakatan assemblymen are that they were all plainclothes policemen, and the police had a heavy hand in that. So the police have not acted in a neutral faction, which they ought to do. So they have been damaged. Then thirdly, the civil servants, whom Shahad has mentioned, and in particular, the staff of the assembly. The staff of the assembly are meant to serve the assembly. They are servants of the assembly. Persons like the sergeant at arms, the secretary, none of them, unfortunately, listened to the only lawfully appointed speaker, which was Sivakumar. From their perspective, Sivakumar was their employer, and yet they totally disregarded him. They didn't care for him, and actually all these things are contempt of parliament. What the police did and what the assemblymen did are contempt of parliament offences. But of course nothing happens. And then finally the courts. The fourth institution which has been terribly damaged is the courts. And of course you know, you don't need me as a court barrister to tell you of the reputation of the courts since the Perak litigation entered the corridors there. If I just give you a few examples, some of the bizarre and unprecedented orders that were made. First of all, and again I declare that involved me, the choice of counsel. I think never in the history of Malaysia, probably never in the history of the common law, for hundreds of years, has a lawyer been told you can't enter the court. And I enjoyed that dignity or indignity. And they said, no, you can't, the speaker can't appoint you and all that. So it's just crazy. And that was, of course, cured by the Court of Appeal. Then the leapfrogging to the federal court. They did not want the High Court and the Court of Appeal to hear the dispute. They just pushed it to the federal court, which was absolutely unnecessary. The great hurry. There was this myth that unless these things are done within 6 months, somebody plucked the figure of 6 months from the air. Somebody else, there's a lot of disinformation at that point of time. Somebody else said that there is a doctrine of automatic dissolution, and if the Perak assembly doesn't sit after 6 months, it automatically dissolves. All that is total nonsense. Things that a constitutional scholar would laugh at. And yet those were the things that were driving the Barisan lawyers and the court and the Attorney General. Then, of course, the total disregard of the immunity points, the 5 cases that were there, which Prof has mentioned, the Article 72, that has a repercussion on federal parliament, and that meant that Gobind Singh, who was around the same time being suspended for 12 months by the federal parliament speaker, that caused problems. And then, of course, the Niza and Zabri decision, which is now awaiting the federal court. Now, I think what I would say is that, and this is where again I would disagree with Shad, I don't think for a minute, with the greatest of respect, that you can have 12, 13, 14, 20 issues, that if you took this dispute to a constitutional court of respect, And what I would say is that one of the good things about Malaysia being a member of the Commonwealth and Malaysia belonging to the common law world is that we share a lot of characteristics with other countries. So of course our intellectual home is always England and the common law, but for constitutional cases we look always to India. And then of course there are 2 or 3 other serious countries that we look into, which is Canada, Australia, perhaps New Zealand, for constitutional issues. And of course now you have the European Court of Human Rights at Strasbourg, terribly well respected, and there's a growing court in South Africa, the South African Constitutional Court. Here I must say, after praising Kevin Tan, I must tell him, the one place that Malaysian constitutional lawyers never look to is to Singapore. Because Singapore does not have a constitution, it does not have a constitutional court, it doesn't have judges, it doesn't have lawyers. So I cannot make this speech in Singapore. So whenever we criticize Malaysia, we must say we are 100 times better than Kiasu Land. After saying that, the point of that story is there are certain countries and their courts which constitutional scholars in the common law world pay respect to. And they are England, Europe, India, Canada, Australia. My argument is if the Perak case went to these 5 or 6 courts, I assure you that our side would have won. Guaranteed. Siva Kumar would have been vindicated, Zambri would have been vindicated, and our side would have been vindicated. But of course, if we had gone to the court of Zimbabwe or Singapore, we would have lost. And that is the point. And I say that because often when you have lawyers and professors and judges and all talking about small issues of law, and you've noticed I've really tried to stay away from the law. I don't want to bore you with the law, the minutiae of the law. The problem is, if you have 10 lawyers, you get 15 opinions. Which is why I often make this point. I say, look, when there is a dispute among lawyers and judges and all, the best way is to say, how would the well-respected courts of the world decide? How will the well-respected courts? And I asked Shah to answer that question. In Shah's opinion, if all these facts, and I asked Kevin to answer that, and all the other constitutional lawyers, if the entire Perak case went to the House of Lords, Strasbourg, Canada, and Australia, what would the result be? And then, so I come to the end of my institutional survey, basically say all 4 of them have been damaged. Ladies and gentlemen, in the final analysis, what happened in Perak was a coup d'etat at both the executive and the legislative branches level. As to the executive, without going through a general election, there has been a change of government. Without going through the ballot box, you have a change of government. That is known as the coup d'etat. You don't need the military. It's not just the military that achieves the coup d'etat. And as the legislature, without complying with the terms of the Perak state constitution, the speaker was forcibly and violently removed, and then a coup d'etat there. Now, in the 50-year history of parliamentary democracy in a constitutional monarchy that Malaysia has, the grab for power in Perak was of the worst kind. Perak will enter our history as a Bible for political chicanery and intrigue. So the only solution, ladies and gentlemen, as advanced by countless persons and organizations, I think if you go on the internet and you sort of collate the number of people and the number of organizations who've said what I've just said, which is the solution is to dissolve the assembly and allow the people of Perak to elect their own government. That is the solution. That is the only solution. And until that is done, and the good news is they can only stretch that to 2013. They can only stretch that to 2013. And that is the furthest they can go. And I tell my friends, every Perakian whom I've met, I'm from Kuala Lumpur, I was born and brought up in KL, but every Perakian I've met since I was involved in this case, they are very proud, regardless of color, gender, sex, age, religion. Every Perakian I've met, and they come and say, look, I am a Perakian. They say, look, we are bitter, we will never forget. We just want our opportunity to be given on the ballot box. So until that happens, there will be bitterness. Not just for members of the NISA administration, they have lost a job. He is now jobless. Apart from them, the good people of Perak who have been cheated and betrayed. And for them, there must be a general election. Thank you very much.